I hope that person was expelled from the school.
One of those part-time just years ago, and,
On the middle of campus, there's some people Saturday nights either would jump in or fall in or just
down the hill. Actually, I deliver papers for about 2 years there once in a while.
yeah, at least people.
Okay.
Hey, Randy,
Yes, sir.
we have to do this thing for our 5 o'clock show.
And it's circuit.
Where it has all the recorders, it's called Head Nod.
Oh, he did.
I went into management finally, saying, never get rid of it. It's like, why? I go, 30 seconds of quiet from the reporter. And they have to sit there.
The bobbing head.
I don't bomb the head, I just, I don't
So,
like a bomb the head.
yes, I'm around the other side, but I also try to joke around. They start laughing. I go, never get rid of it. It's the best 30 seconds of my day.
Yeah.
I still talk all the time. Be miserable.
Good job, Karen.
Where did this incident happen? What's it, in Barberton or?
Which, this here, what you're talking about,
How do you get assigned certain things?
I remember that.
Did you see the video?
I saw the video and.
Surveillance or whatever?
Yeah,
Yeah.
we have that pulled up, we have all this stuff.
Wow.
My reporters never pull video.
Thank you.
That would be a blessing.
I worked with somebody, we're getting to know each other. I go, did you pull video? Because she shows up an hour and a half earlier. She goes, I looked at it, I go, you didn't down, and she's from another grade stage. So she knows the system. I go, then you didn't download the video. And we're driving down the side street, goes, no, it's not my job. I go, it's our job to do the story.
Wait, is this someone who works at the same university?
I'm not saying. It's our job to do the story. At times I'll help you, at times, when you're staying for an hour and a half, you should be advancing your story, not waiting for me.
Always good to know that that's a good one.
The day I say that's not my job.
Yeah.
I might say that junior. But I'll never be serious with me.
It's good to see you back.
I know, I said, I go, Nancy, I said, what are you doing? You're like, I said, I'm gonna eat all your candy canes, somebody else is eating them.
So can you think that if you was the lake now that they took some children pictures? It's clear.
Okay.
So Lisa, just put it back on the, you want to put it back on your desk.
And when does she come back? Did she pay the 100?
No. Not yet. She's just being nervous now.
Just.
She's being, Adam's getting court.
Okay. When Adam gets that court date, then I'm gonna attach this to that court date. Okay?
Yeah.
Thank you. Thanks for doing that.
Sure.
Thanks, Mike.
Yeah,
Appreciate
we
you.
came there.
It's next to blue, green, yellow.
Yeah, makes sense.
Not the brightest ball, but yeah. Blue and yellow mean green.
I know, and that's.
I mean, it's funny.
This is some blonde.
Window, you can see the lake better to see what those trees are.
You're sorry.
That's on you.
Sorry, I'm
I
holding.
bang my, yeah, check all the time. I always have to replace my glass cover since they do. Constantly hitting my, do you know that?
Forgot. Yes, but I forgot to put my, I had a film in it, and I
Andrew's usually board that for this first.
Yeah,
10
They
years.
might be in city council chambers, the door.
I just refer to myself as the Barnett, because she's the one who
You just changed it. That's what all the hippies.
She's not cool enough to have TikTok.
I don't have time to help you. Yeah, create
It's a dive bar, but he's really good.
That's a big trial.
Easy parking.
Starting,
Don't
what do you think up into the ones?
I
It's the pizza delivery murder case.
park next to me, pulling in, it's like,
Being tried for a second
go
job.
back, so you don't have to.
Probably will be new to
Somebody with something.
the midday.
You come in here, and they can
That's right.
up the ante from your own. I've never seen that.
The old.
Not tall enough, so look, I was trying
I
to
know,
look at it. With the-
I was thinking about that too.
Stephanie, did you send it from your S1?
Yeah.
Now we're finding, I'll be like, look at us.
Did you find it?
Not yet, I've done a search on it. I just thought you could read it.
Yeah, we didn't get that.
I sent it at 4:30 yesterday.
It's crazy how they
I
only
don't.
budgeted for
You sent it to Mike Carr through Sen?
certain parts of the building.
I sent it to your beacon email.
Okay, I don't have a big email on this.
And I mean, I think some of it
I'll
was,
take a look at it.
this was gonna.
I will
send
forward it
this
to
in,
Jeff.
this
Okay.
was gonna, like, change up and they were gonna push Pardon?
I thought it was all agreed upon.
Yeah.
So they said when he took the plea deal.
Well, the judge doesn't have to accept the recommendation. It's a recommendation.
So when they give probation and pre-sentence investigation, the probation still has to give recommendation
Give a
for the
recommendation
judge
to
to
the judge.
actually, so
Yeah.
it could,
In general, though, it seems like the judge follows what the attorneys have agreed upon.
Unless things have changed since then.
Yes.
Right.
Has it been like 2 months?
It has been, yeah, it was in November when he
November?
Yeah, it was so warm out.
Oh,
Yeah, because they have to be cooled out.
it seems like it was so long ago, but.
Welcome to the new weather pattern.
Randy, do we need a cuddle so you get warm again?
Can you do the big spoon this
Get a
time?
room. Get a room. That's,
I'm about to fall asleep. Perfect. And perfect. What's his first name? I'm sorry?
This is the kind of craziness.
You mind going out to the car?
Yeah, where you?
Another camera battery. And you open up the hood of the bed. There's a drawer, there's a latch. The top drawer has a couple of camera batteries.
We're in the lab, the top floor. Got that. Hold on.
They're dated on the side,
Okay.
so it's try to find the more recent one.
No, we figured the wrong thing.
I'll take a Coke.
Anyone else?
Do I have some in the evidence locker?
At least that'd keep me awake.
That's a copy of it, you all be running through there.
Yes. like starting stuff. Anyway, that's how I ended up in ICU.
I've only caught part of that, and I was like, end up in ICU, that can't be good, can it?
It's a joke.
Hey, Mike, did you bring your laptop?
Another one.
Yeah,
I live in
Yeah.
constant fear
Yeah,
that
it's in
if
my car.
Donald Trump is reelected, he will
I just
support my
wondered, 'cause I'm gonna go
mother-in-law
over
who
to
works
copy
at
files.
2763.
I can't hear him, Marty.
He
What?
works over, gets home around 3 and drives a green machine. That she'll get deported.
If this ever happens, afterward, I'm gonna go over to copy and file it later.
Yeah, that's what I was thinking. Yeah, that was my game plan.
Can I, what's the
Oh,
difference
physics
between
English.
some big, some little? They all do the same thing?
No, the bigger ones are better. They give the smaller ones to the inadequate photographers.
Oh. Is that your biggest thing?
I didn't try texting.
I don't, they perform to the viewer at home the same, so.
Okay.
It should be done.
I'm
I just
actually
wondered.
happier because my shoulder
Unless you
doesn't
got
I
hurt.
was gonna say, it's
Mm.
like, that's like a lot to carry around.
I know, that's true.
But he also has a lot of emotional motivation.
Oh.
Did you see anyone while you were out?
Nobody was out there. And I don't know what you were saying about me when I was gone.
No, nothing.
Which one was supposed to do?
I was telling some cute jokes from the sky clip.
No, I don't see anybody out there, it's just people waiting on the street.
My love is big.
Man, I hate stuff on Friday afternoons. It's the worst.
Have officially reached support.
Don't touch me.
Oh.
I have to do HR or
And sometimes everybody showed up early, we're here at 12:30. Well, I was
Yeah,
thinking,
you
like,
should- you should bring the prices down.
Again, I avoid this,
Thank you.
but usually it's in and out.
was my description.
Yeah.
Good afternoon, everyone. Welcome to the court. Have a seat, those that are standing. Thanks for your courtesy. Jen, I'm gonna give you yeah, if you will, please. Thank you. You think that I could have done that, but I'm sure I would have messed it up somehow. So we are on the record now. Today is the 5th day of January 2024, and we are convening in the cases involving Robert F. Young III. Mr. Young is present for sentencing in the cases, represented by Michael T. Callahan, attorney at law, Akron, Ohio, retained legal counsel. Unfortunately, Mr. Grevin, John W. Grevin, also counsel for Mr. Young, was not able to be here today because of a personal family matter. And Jen Roberts represents the state of Ohio, she being, of course, an assistant city prosecutor in the city of Barberton, Ohio. And I am presiding by the authority of the Supreme Court of Ohio in these cases upon the recusal of the elected judges of the Barberton Municipal Court. The history in the case is something that will be of some importance. I'm going to discuss that in a moment in terms of bringing us up to speed for today's hearing and what we'll be accomplishing at today's hearing. But it is also important to know why we got started 50 minutes late, being almost 10 to 2. And the schedule time was 1 o'clock. And that is because I have been in some serious discussions with Ms. Roberts and Mr. Callahan relative to issues that are germane to today's hearing. And there is, first of all, as a matter of business, a motion to revoke bond, or to modify, I should say. Motion to modify or revoke bond filed by Ms. Roberts on December 27, 2023. I want the record to reflect that when that motion was filed, I was notified by Ms. Roberts' office that the motion had been filed. A copy was emailed to me, and I worked with the court liaison, Mr. Incorvati, as an intermediary between Ms. Roberts and me and Mr. Callahan and Mr. Grevin and me as to how we were going to handle that motion. Again, that was December 27, today is January 5. There were limited dates upon which I was available between that notice coming to me and today's date. I asked Mr. Incorvati to discuss with Ms. Roberts. I don't believe I told Mr. Incorvati to have any contact with Mr. Grevin or Mr. Callahan, but to have contact with Ms. Roberts in terms of how she wished to proceed on that motion, having a hearing prior to today's date or addressing that motion today. So I'm going to ask Ms. Roberts, for the record, to supplement my remarks, Ms. Roberts, with things that are of concern and importance to you relative to that motion.
Thank you, Your Honor. Yes, the state did file December 27th motion to modify or revoke Mr. Young's bond. We did receive notification through our probation department, through Oriana, that there were multiple tampers with the scram unit, and that becomes concerning to the state with respect to the potential of tampering to avoid detection of alcohol. And as a condition of bond, the court did order Mr. Young to wear that scram monitor and not to consume alcohol. After the filing of that motion, I believe earlier this week, I did receive another notification that there was an additional tamper. So at this time, the state has notification of 5 potential tampers from Mr. Young using the scram device. Therefore, we did file the motion to revoke the bond. With respect to that motion today, Your Honor, based upon the pre-trial discussions or pre-hearing discussions today, the state, in order to proceed forward with sentencing today, will withdraw that motion, although we will be addressing our concerns that we had in that motion during the sentencing hearing. And I would just, so formally withdraw that motion so that we could proceed forward with sentencing today, and I'll address those concerns with the court prior to the court sentencing.
Okay, and Ms. Roberts, as part of our discussion, Mr. Callahan, you and I, and your decision to withdraw the motion to revoke or modify bond, was my having communicated to you that if that motion was one you wanted to be heard, that it would not be heard today, that we would set it for an evidentiary hearing, that Mr. Young would have the due process rights he has relating to any suggestion that he violated bail or bond, and that a decision would be made relative to your motion, either granting it or overruling it after a full evidentiary hearing where Mr. Young was present, represented by counsel, had all the opportunities to challenge that evidence.
Correct, Your Honor, and I will state for the record, the state did have an individual from the Oriana House here
Yeah.
today to present testimony regarding those tamper or alleged tampers.
Right.
When I was asked when we would have a hearing, I believed that hearing was going to be today with respect prior to the sentencing. And so at this time, knowing that everything would get postponed, I feel like the option that the state has is to withdraw that motion at this time
I
and
understand.
proceed with sentencing, so that sentencing can be complete today.
Okay, thank you, Ms. Roberts. Mr. Callahan, your comments.
Thank you, Your Honor.
Mhm.
May it please the court, as I understand, the court ruled at one point in time as a condition of bond that Mr. Young not consume alcohol. And to ensure that that was the case, the court put a scram unit on him. It's my understanding that there are some, I guess tampering is probably the best way to put
The allegations.
the allegations of tampering. Your Honor, I've had some experience with this in the past. First of all, let me say my client adamantly denies consuming any alcohol during the pendency of this. Willing to do whatever it takes to convince the court of that matter. I am personally aware in past instances that there are a number of ways that the scram unit can show these false positives. I've gone so far in other cases of hiring experts from out of state to come in and testify to that, and would be prepared to do so in this matter if it was necessary. Therefore, it would have been our request to have a separate hearing
Correct.
if the court wished to go forward, if
And
the
I
state wished to
suggested
go
that
forward.
would happen, yeah.
Based upon the state's withdrawing the motion, we are prepared to go forward with sentencing then today.
And it's my understanding, both Ms. Roberts and Mr. Callahan, that I communicated to Ms. Roberts that her concerns in that regard can be part of her remarks prior to the imposition of sentence in this case. That
Certainly.
Those allegations, and you would have the same opportunity.
We will address it as well.
Okay.
Thank you.
So I want to make sure that Ms. Roberts, Mr. Callahan, have spoken accurately concerning our pre-hearing discussions. Yes, Ms. Roberts?
Yes.
And Mr. Callahan?
Yes, sir.
Okay, all right. Now, that having been addressed, let me briefly indicate what the procedural status of the case is, how we got to today's hearing, so that the record clearly reflects the procedural history in the case. Mr. Young was charged in three cases, three open cases here with misdemeanor crimes. In the first case, which is numbered CRB 2301403A, the first count, the charge was domestic violence, revised code 29-1925 AD2 of the code was implicated, charged as a misdemeanor of the first degree, and the alleged offense date is July 8, 2023. In the second case, numbered CRB 2301-1786, the criminal complaint charges violating a protection order. Revised code 29-1927 is implicated, charges a misdemeanor of the first degree. The alleged offense date was August 26, 2023. In the third case, which is numbered CRB 2301923, There are 2 counts. A is the first count, B the second count. In count A of that complaint, the charge was menacing by stalking originally in that complaint, implicating Revised Code 2903.211, charged as a misdemeanor of the first degree, with the offense date being July 31, 2023. And the second count of case number 2301923 was violating a protection order, again, Revised Code 291927, misdemeanor of the first degree, the offense date being the same as the alleged menacing by stalking, July 31, 2023. Now, those charges now have been considered, and events have occurred in the case which have brought those charges with an amendment to one of the charges forward to today's date, where findings of guilty have occurred on particular charges in these cases. And the hearing today is, of course, for the imposition of sentence. The record should reflect that the domestic violence count in case CRB 2301403A was tried to the bench without the intervention of a jury on October 24, 2023, and a verdict judgment entry was returned by the court on the 27th of October, finding Mr. Young guilty of domestic violence as charged in count 1 of that complaint. It is also of note that a companion charge of assault, also a misdemeanor of the first degree, in case CRB 2301403B, was addressed by the court at the bench trial, and a verdict of not guilty was returned on that count. Mr. Young was acquitted of the charge of assault. As it relates to the second case, CRB 230111786, violating a protection order, there was a criminal rule 11F negotiated plea agreement reached between the state of Ohio and Mr. Young relative to that charge, and he was found guilty by a judgment entry memorializing that agreement on November 17, 2023. So violating a protection order in that case, a finding of guilty based on the Rule 11 negotiated plea agreement between the state and Mr. Young. In the third case, CRB 2301923A, the first count, violating a protection order, Mr. Young was found guilty of that charge, again, by virtue of the criminal rule 11F negotiated plea agreement, judgment entry memorialized on November 17, 2023, and the second count, the first count of that 2-count complaint, the menacing by stalking, was amended to a violating a protection order charge, misdemeanor of the first degree, and based on the agreed resolution between the state and Mr. Young, a finding of guilty was entered on that charge, the amended charge of violating a protection order, on November 17, 2023. And then the second count of that 2-count complaint in CRB 2301923, violating a protection order, the agreement between the state and Mr. Young resulted in a guilty finding and memorialized on November 17, 2023. So we are today here for the imposition of sentence on the count of domestic violence, a misdemeanor of the first degree, and 3 counts violating a protection order, all misdemeanors of the first degree. Ms. Roberts, do you agree in my recitation of the procedural resolution of those charges?
Yes, Your Honor.
And Mr. Callahan?
Yes, Your Honor.
Okay, good. Now, always want to make sure that there's no disagreement on what we're going to be doing going forward. So now, as it relates to the imposition of sentence, Mr. Young, it's important, and I know you've discussed this with Mr. Callahan, but it's important for me to communicate to you the structure of this sentencing hearing. It is all decided by the rule of law, The law addresses what must be done at this hearing, what can be done, and what cannot be done in the case. And so you have been found guilty of those 4 charges that I just recited. And the next phase of the criminal proceeding is the imposition of sentence. At this hearing, it is required that the prosecuting attorney be given the opportunity to speak on the issue of sentence in terms of what she believes in light of what she understands to have been the facts underpinning the complaints in these cases, as well as now the motion to modify or revoke bond, which she talked about. Ms. Roberts is going to have the full opportunity to comment as to what she believes an appropriate sentence then would be in light of these matters, and that is provided by law. She must be given that opportunity. Next, your attorney, Mr. Callahan, must be given the opportunity to speak in your behalf in terms of his comments, what he believes is appropriate, commenting on what he's heard Ms. Roberts say, other matters of importance as it bears on the sentence that the judge ultimately will impose in the case. Next, you, Mr. Young, are by law provided the opportunity to be heard. You must be given that opportunity to speak on issues that are important to you, to comment. It is essentially open-ended. Of course, there are limitations in terms of time and also content. I don't know if anybody saw the same news report I saw last night about the event in Las Vegas in the trial court there, where there was one of those things that you never expect to happen, but it did in terms of the sentencing hearing. So, not that I would expect anything like that, but that is important, that you realize that you have that absolute right, Mr. Young, to be heard. And for me to consider what you're saying as it relates to sentence. I overlook the fact that the victim in these cases, Tina Young, your spouse, who is not here, as I understand, Ms. Roberts?
Correct, John.
Right. But who has been in touch with Ms. Roberts and the probation office, and has chosen apparently not to appear today, but her concerns are going to be verbalized by Ms. Roberts, who represents now the victim of these 4 misdemeanor charges. So the law provides for victims having this opportunity to be heard by the judge before sentence is imposed. And again, Ms. Roberts will be the mouthpiece for Ms. Young in that regard. And then ultimately, after I consider the comments of counsel and you, I'll impose the sentence that I believe is appropriate in this case. And as we discussed in general terms at the Criminal Rule 11F negotiated plea agreement hearing that was conducted in this case, resulting in the findings of guilty on 3 of those 4, and of course the verdict of guilty on the 4th, the domestic violence. So all that is going to occur, and when I'm done listening to you all, I will then impose the sentence that I believe is appropriate, as I've said. The last thing before I ask Ms. Roberts then to speak on behalf of the state and the victim, the backdrop to this hearing is provided by law, and I told you all these things are rooted in the law. The overriding purposes of misdemeanor sentencing in Ohio are provided in Revised Code 292921A. And very briefly, this is what the overriding purposes of misdemeanor sentencing in Ohio are. They are to protect the public from future crime by the offender and others, and to punish the offender. To achieve these purposes, the sentencing court, that is the judge, shall consider the impact of the offense or offenses upon the victim and the need for changing the offender's behavior, rehabilitating the offender, and making restitution to the victim of the offense, if that's germane, the public, or the victim and the public. So those are the purposes, overriding purposes of misdemeanor sentencing. And those are always ones that are going to be considered in the sentence that will be imposed now in this case. So with that, I'll ask Ms. Roberts then to make comments that she believes are appropriate.
Thank you, Your Honor. I'll start by indicating that I have been in continued contact with Ms. Young, the victim in these cases. She did wish not to attend the hearing today and indicated to me that she would respectfully defer to the court's sentence with respect to this and did not wish to make recommendations.
And Jen, can I interrupt? I want to say one more thing for the record. The probation department did prepare and file a pre-sentence investigation report. I received it, have reviewed it. The prosecuting attorney has as well. Mr. Callahan hasn't, as I understand, but nonetheless, there are recommendations that are made there that the court is not bound to follow, but are nonetheless there. So sorry for that interruption.
That's okay. So Ms. Young did wish to just defer to the court with respect to what the sentence would be. With respect to the state's position, Your Honor, there's a few things that the state looks at with respect to sentencing in these misdemeanor cases. We'll start with primarily an acceptance of responsibility. And is there any remorse of the defendant? Will there be lessons learned from this moving forward? The next thing that we are looking for is the defendant willing or able to follow the court's orders with respect to orders of probation if that's what the court would choose to do. And it goes back to acceptance of responsibility, an acknowledgement of the underlying issue. In this case, the state's position has been, the underlying issue has been fueled by alcohol consumption. Mr. Young has, throughout the pendency of this case, struggled following the court's orders. The court placed a temporary protection order in place, and he had numerous violations of that protection order. And we knew that when we did the plea previous.
Mm-hmm.
When we did the plea, the state asked this matter to be set for a pre-sentence investigation so that the state could get a little more a deep dive into whether or not there was an acceptance of responsibility, whether or not Mr. Young was remorseful, and whether or not he was willing and able to comply with any recommendations for treatment and acknowledge that alcohol was a problem. Throughout the course of the pre-sentence investigation, as the court is aware, on November 16th, they did place Mr. Young on that SCRAM monitor, which is a continuous alcohol monitor to detect alcohol consumption. So approximately 45 days from today, we've had 5 confirmed tampers, and there's a process to confirm a tamper. It's not just a one-step thing. Oriana has confirmed those tampers. While Mr. Young can continue to deny that, and counsel can say that this happens a lot, we place a lot of people on SCRAM. The percentage of tampers that we receive are pretty minimal. The fact that we've had 5 in 45 days is very concerning to the state with respect to continued alcohol consumption, which goes to whether or not Mr. Young has acknowledged that alcohol was a problem with this issue. The state has concerns about his acceptance of responsibility, about his remorse for the actions that facilitated these charges coming forward, as well as the findings of guilt. The state has concerns about his acknowledgement that alcohol is an issue. He was assessed for alcohol, and that did make recommendations, but throughout that assessment indicated that there was maybe a lack of truthfulness or a self-protect about how much alcohol was impacting his life. Which is concerning. In addition to those SCRAM violations. But the biggest thing for the state is Mr. Young's inability to follow the court orders. That we're going to put him on orders, right? Whether that's community control, some sanctions, he's going to be placed on orders. At this point, we have concerns about his ability to follow those or his willingness to learn and actually take in what's being ordered, not just go through the motions and complete the programming. Obviously, the goal would be that there be something learned so that behavior can be modified, as the Ohio Revised Code would indicate.
Yes.
And so that we're not back here again at a future date with similar instances. because nothing was learned. That being said, at this time, I just want the court to be aware of the state's concerns.
Right.
Particularly with that scram, we did withdraw that motion to revoke the bond today. I'm here to say if the court orders Mr. Young on scram and I get more tamper notifications from Oriana, there's going to be another motion that will be promptly filed with respect to that. I think that that is extremely concerning to the state. With all that said, we would defer to the court with respect to sentence. I just want the court to know that we do have concerns about willingness and acceptance of responsibility and remorse moving forward. It appears as though there's been, even through the probation report, some minimization of actions and minimization of what led us here today, and that's extremely concerning.
I think Mr. Young's on notice, Ms. Young, Ms. Roberts, that you're going to be looking at this carefully going forward. Thank you for your comments. Mr. Callahan.
Thank you, Your Honor. Your Honor, Bob Young is before you today, 42-year-old man, never been in trouble before in his life before this instance. We can talk about all the problems that has occurred since July of last year, but for the first 41 and a half years of his life, he led a law-abiding life, never crossed paths with anybody else in the law, never in front of a court, never in front of a judge like yourself. I got to tell you, Judge, this is all new to him. I know it's not new to me, I know it's not new to you, it's not new to the prosecutor, but it's all new to him. And I think that is evidenced by his actions and activities after he was initially charged. I can think of no greater way to accept responsibility for your actions than to stand before a judge like yourself and accept it by pleading guilty. And that's what he did in the final 3 counts of this case. He has accepted responsibility for those actions. He might not agree with everything that came out of the initial trial, but he's accepted the court's ruling, the court's decision, and is moving on with what needs to be done to get at least a semblance of his life back. He has lost a great deal already. The punishment that comes with a case like this is great on anyone, but on Bob Young, it's been greater than most. He's lost a political career, a very promising political career. He's lost an ability, or at least a portion of an ability to make a living based upon some of the conditions that this conviction will bring. And perhaps more importantly, he's lost his family. Your Honor, he can't get back the political career. He can't get back some of those things, that those rights that the court's going to take away from him and his ability to make a living. The question remains is whether he can get his family back or not. I know he's made steps in the last 7 weeks to do that, but the question really remains to be seen. He's paid a heck of a price. Judge, I'll just talk a second about I mentioned briefly about the scram unit. I'm aware that there's other ways, if the court is truly only interested in keeping Mr. Young from drinking, perhaps I would ask the court to check with the probation department about an in-house breathalyzer that would accomplish the same thing. It's something that I know another organization in the corrections world runs, but perhaps something like that would be more appropriate and would not have the same type of situations that we've talked about here today. Ask the court to at least think about that. Finally, Your Honor, he spent a couple days in jail. He knows that he doesn't want to go back there. He's willing to do whatever this court deems appropriate for him to do to get his life back on track. I'd ask you to inquire of him.
Thank you, Mr. Callahan, for your comments. Mr. Young, as I indicated, you must be given the opportunity to speak. You have the choice to say nothing or to speak, and so I'm going to give you that opportunity now.
Well, thank you, Judge. I appreciate that. Throughout this process, I've been pretty silent and just let my attorneys represent me,
It's true.
which
That was not easy to do.
well, it was the best thing to do, and I appreciate obviously what my kind words and the accurate, honest words that my attorney just said. And a lot of what he said is exactly how I feel. I've had a good life. I'm really proud of my life and my family. There was corners in my life where they probably weren't how they seemed, and there was room for a lot of improvement. And the last 6 months has probably been, it has been the darkest season of my life and most challenging. And my wife and I have accomplished a lot together. And to go through a season like this that has been more challenging than that, I never foreseen it. Because I thought we were very successful on so many levels. I really enjoyed my work. I felt privileged to be a state representative. I was really proud of that. To represent my community, be an example to my children. In life, I did a half a dozen things financially, and I always kind of found a new career. I was fortunate enough, and I still am, to do work that I love. And my wife and I were like living examples to our kids that you can do anything. Here's a couple hardworking people from pretty average means that done well. It took me, it was a learning curve. I had a sense of entitlement, probably swelling up with pride when this process first started. And it took me probably 40 days to get my head right and wrap my mind around this. What I know about judges, I like them. They're my friends. Authority, law enforcement, I respect them, I support them. I understand the value of them and the hard work that they do every day to serve and protect. Judges are my friends. But I found myself on the other side, on this side, which is a lot different than walking in a parade or going to a fundraiser for a judge. And it was a lot for me to learn, and I've learned. I accept responsibility for what I'm responsible for, and I will admit that, post the first couple of charges, that I wasn't my best self. I didn't represent myself well. Embarrassed myself, embarrassed my family, embarrassed my colleagues. If we could get do-overs, things would be different. But all I can do is go forward and be a better version of myself. I've taken strides over the last 6 months, whether it's personal counseling, marriage counseling, not drinking, to better myself and my family. And I can say honestly today that in my heart, I feel better about me than I probably knew I was 6 months ago. Probably saying too much, but I respect the court. I respect your authority. The way you conducted the trial was nothing less than professional. I respect your demeanor as a judge, and sincerely. And I accept responsibility for my bad actions. We will work through this. My wife and I have had good communications lately. We've had healthy interactions. We've had quality time with each other and with our family. And outside of that, that's really what's most important to me. I had no idea. I have to say something about the Scram device, if you don't mind.
Not at all. This is your opportunity to comment.
A couple weeks ago, the Arena House called. went there, they put the ankle monitor on. I showed up on Mondays when it was the download day. If it was a holiday on Monday like Christmas and New Year's were, I went the day before, the day after. The caseworker called and said there were some discrepancies and she wanted me to come in and check the fit on it. I was there within 30 minutes and I have a panic because after those couple of days in jail, disrespecting this court and losing my right to freedom or that bond wasn't an option. It was a real come to Jesus, if you will. So I was in panic when I went there. And she said, well, there was 4 days where this thing wasn't working properly or it was being tampered with. Tampered with sounds like I was taking it on or off or messing with it. She checked the fitting. It was fine. She said there was low levels of alcohol. I had no idea why. If this bracelet continues to be on here, I'd ask that the court, did I get a new one? Because I'm really nervous and I don't trust this thing. This thing on my ankle could determine my freedom in the future. And I understand what it was like to lose freedom. Barely, but I do. Right. And not having my freedom and not having the ability to fix my relationships with my family and working and provide for them, it's not a good option for me, Judge. So I understand the implications of that. That's really all I have to say. One other thing I would like to address, the low light of all of this, I mean the whole process, was when I sat in that seat and I was put in a position to refer to my daughter as a liar. I guess it was a fair question. I answered it very, very poorly. And my daughter's not a liar. So,
I didn't think she was.
she's not. Her perspective's different than mine. But, I apologize for that. But that's all I have to say, Judge. Thank you.
Thank you, Mr. Young, for your comments. So, I come to this day, having given a lot of thought to what I've observed, heard, assimilated during the trial, other hearings, including today. All are things that judges are required to take into account in determining what would be a fair and just sentence in the case. And so I have come to conclusions that I feel very confident are appropriate, correct from my point of view, judicial point of view, and I'm prepared to conclude these proceedings with the imposition of sentence on the 4 charges that I've announced earlier in the case. I'm not going to go over them again. So we've got the 1 count domestic violence, 3 counts violating the protection order that remain in the 3 cases. I'm of the mind that a period of community control sanctions, what we used to call probation, but now is called community control sanctions. And there are essentially 2 types of community control sanctions. One is supervised community control sanctions, where a probation office is supervising the conduct of the person on community control sanctions, on probation. And then there's a concept of unsupervised or non-reporting community control sanctions, which is essentially good behavior, where someone is not going to be reporting regularly to a probation office. The law provides for a maximum of 5 years of community control sanctions, whether they be supervised or unsupervised and non-reporting. So the first decision that I have to make in these cases is, would a residential sanction, i.e. jail, more than the time you spent there upon your arrest, would that be a fair and just sentence in this case relating to your conduct? In thinking of that, of course, it's like addiction. Yeah, as a judge, and as lawyers, prosecutors, defense counsel, we have for years and years, and I've been at this now for 42 years, you come in contact with people with serious addiction issues. Now, I'm not suggesting that you are addicted to alcohol. Alcohol's an issue here, and I'll address that. But that concept of addiction to drugs or alcohol, I can acknowledge it, but I can never say I understand it or appreciate it, because I don't. I haven't experienced that. The same is true of loss of liberty. I can't tell you that I appreciate what your loss of liberty, which is compared to many people, minimal, but nonetheless, in your life, I'm convinced, traumatic event, as it would be for most people who have never lost their liberty. They have no control over their environment and contacts and all of those things. So I can't tell you that I understand what you experienced or what any man or woman experiences when they lose their liberty. But I take that seriously. What I'm trying to communicate to you is that my responsibility as a judge is to impose a sentence that addresses the issues that have been presented and underpin the crimes that have been committed, the criminal conduct that has occurred, but not to go beyond that which would be just. Or, on the other side, to not impose a sentence that is appropriate based on the conduct involved. And I have concluded that based on your lack of a record, as Mr. Callahan spoke and Ms. Roberts acknowledges, you have no criminal history. That's a factor that judges certainly must take into account. Today, your comments. Again, Ms. Roberts is entitled to opinions that she has based on things that she has mentioned. But it certainly sounds like genuine remorse to me, Mr. Young, and I'm going to take it as that. And I hope that I'm correct in my assessment. And of course, there's that old saying that the proof of the pudding is in the tasting. And that means, you know what that pudding is once you taste it, but before that you don't. So in this case, we will know the depth of your sincerity going forward by your conduct and about and how you accept the sentence that's imposed and comply with the requirements of the sentence. So in each of these misdemeanor counts, there are misdemeanors of the first degree. There's a maximum 180 days in jail that can be imposed on each of those counts. I'm imposing no further jail term on any of those counts. I'm giving you credit for the time you served at the arrest, but those total of 2 years is out there, Mr. Young, and the law provides that if you should violate the orders I'm going to tell you I'm imposing in a moment, there would be the potential for a maximum of 2 years in jail, which is unthinkable for most normal people, and I'm assuming for you as well. So, but that is a potential punishment that can still be imposed in this case if you would violate the orders that I'm going to be imposing in terms of your supervision. And the law provides that as a punishment for violating court orders and sentence, the period of time that you're under supervision can be enlarged as a punishment for violating the court orders up to the maximum of 5 years. And then there is, again, the potential for violating the court orders that I'll announce in a moment of jail time that could, in the worst case scenario, accrue up to 2 years, maximum in this case. But again, I don't expect that to be in the realm of possibility. So I want to make sure you understand the repercussions of violating the court orders. So the sentence relating to these 4 misdemeanor charges is a period of 1 year supervised community control sanctions. That is reporting probation. You're gonna leave the courtroom today and report to the probation office. Mike, I wanna make sure that you get him there. I will be issuing the sentencing orders and a judgment entry that I'll transmit to the court. I've already spoken to the administrative staff. That'll be journalized either tomorrow morning. It's a Saturday, but there are situations where the court has conducted business on Saturday. But if it's not journalized tomorrow morning, it'll be journalized first thing Monday. That'll be the entry that will reflect the orders that I'm imposing. So for that first year, it's going to be non-reporting probation. There's going to be a second year though. So it's going to be a total of 2 years. That second year would be non-reporting or unsupervised, essentially good behavior. And it would be up to you as to whether any further contact would be occurring between you and the probation office. It's important, Mr. Young, during that first year, starting today, ending on the 5th of January 2025, you will be following all instructions of the probation staff. I am delegating that authority to supervise you to them. I'm not going to micromanage your supervision. The rule of thumb is you do what they tell you to do and you don't do what they tell you you're not allowed to do. You may have some disagreement with things, but that is your responsibilities to follow their instructions so that you are not accused of violating the court orders and then consequently coming back to court in the case and possibly having sanctions imposed for violating court orders. So 1 year reporting starting today, you'll go to that office and then on your way after that. And then I would be certainly open to a suggestion by the probation department if you do this 1 year in an exemplary fashion to terminate the supervision after 1 year if another year is not, in the opinion of the probation department, needed based on your performance in that first year. So what else? Generally follow the instructions of the probation staff, as I've just indicated. There will be no residential sanctions. That means there will be no additional jail term imposed. That's part of community control sanctions can be a jail term, but that is not going to be the case. Non-residential or non-jail types of sanctions are the following. Whatever the rules of the probation department are, again, you follow them. It's that simple. In the pre-sentence investigation report, I've been given information that's important, and I'm going to indicate as part of your supervision that you continue and complete intensive outpatient monitoring by the probation department and whatever agency. I believe it's Summa Health, I'm not sure, but in that regard, you follow the instructions of the probation staff as far as that intensive outpatient counseling and treatment relative to alcohol consumption. I understand that you mentioned are in counseling, personal and or family counseling. I want that to continue because as I indicated earlier in another hearing in your case, Mr. Young, the most important thing to me in this case now going forward is that your family heals, that you and your family heal. And you mentioned that, you spoke to that. And to the extent that this is going to be helpful in that regard, you'll continue counseling there until the professionals say that it's no longer necessary for you to continue on. As you might imagine, no alcohol is allowed to be consumed under any circumstance. You'll be, as I said earlier, prohibited from entering to bars, taverns, places that sell alcohol as their principal business function. A restaurant that is in business to serve food and has that ancillary service of liquor, you can go to those places, but you cannot go to a bar. And I think you know, we all know what a bar is and what a restaurant is and the difference between the two. If you're going to err err on the side of not going into a place if you're not really sure if it's a bar or a restaurant. Err on the side of not going in. The scram device, it's going to be again at the behest of the probation staff, and that'll be something you'll be required to have going forward in this year. Should they conclude that it's no longer necessary, then I endorse that. Again, I'm not micromanaging this, but it is the authority of the probation department to monitor that, and that will continue as long as they believe it's necessary. Lastly, is a non-residential sanction, and I think this is very appropriate in your case because of your talent, your skills, your accomplishments in life, and I recognize and acknowledge all of those. So it's not like it's all bad. You've spoken to many of those successes and accomplishments. I believe that you could be of great assistance and help in making this community a better place. So I'm going to require that over the course of this next year, you perform 250 hours of community service. You can make a real contribution, Mr. Young. Now, what that will be, that's between you and the probation staff. And I'll approve and tell you right now, whatever they and you agree upon, that's fine with me. But I think you can give to this community even more than you have in your service as a state representative or otherwise. You can make it better. So I believe that's an important part of your sentence. And then lastly, there are financial sanctions under the law. Any supervision fees, any fees that are required to facilitate your community control sanctions, you'll be responsible for payment of those. And then the payment of court costs in these cases. That'll be a bill, I assume, the clerk's going to send to you. I don't know how they do it here in the Barberton Municipal Court, but typically clerks send bills to people who owe court costs, and I know you'll take care of that in a prompt fashion. That's it. If you are successful in completing this sentence, there'll be no further repercussions. But again, there would be serious consequences for violating. Ms. Roberts has let you know that she believes that you engaged in tampering. You can prove her wrong to the extent that you can do that by going forward with no further issues. Take that up with the probation department. You're concerned about the device that you have now. However they handle that will be their business, but I certainly would do that if I were you. Voice your concerns to them. So in announcing that sentence, I'll reduce it to writing in a judgment entry that, as I said, I'll transmit to the court administrator, who will then docket that, or rather file it, and it'll be docketed by the clerk either tomorrow or Monday. But those orders are in effect now, Mr. Young. It's not a situation where they're not in effect until that entry is filed. And I'm going to ask you to go to the probation department then on your way out of the building. They are in the building, Jen? Is that right?
Yes, sir.
Yeah, okay. And then once you're done there and they tell you you're able to go, then you're on your way. Do you have any questions about the sentence I've imposed, Mr. Young?
No questions.
Okay. Thanks for your patience and your attention. I appreciate that. In behalf of Mr. Young, Mike, anything further?
Nothing further, Your Honor.
Thank you. And for your representation of Mr. Young and Mr. Grevin's representation, I want the record to reflect he received excellent representation in the case, no doubt about it, in my opinion, as well as the state of Ohio having received excellent representation by Ms. Roberts. Ms. Roberts, anything further in the case?
The only thing, Your Honor, is you indicated he'd be ordered to pay the court costs. Is the court going to issue a fine or?
No fine, right. I always view a fine as something that should not be imposed in addition to other aspects of the sentence unless it's a deterrent, and I don't see that applying in this case. So no fine. Anything else? Any questions about the sentence or things that you're concerned about that I may have overlooked?
No, Your Honor.
Okay. If there's nothing else, then we'll adjourn. And Mr. Young, I wish you and your family the very best.
Appreciate that. Thank you, Judge.
You're
Take care.
welcome. Thank you, everyone. We'll be in recess then. And you don't have to wait for me to go. Everybody can disperse as they wish.
And you'll make sure you get still close.
Jen, how was the tape recording turned out?
Okay.
Would you do that? Thank you. And thanks for your help.
You can, once that comes to the court, can you make sure that I